Hello and welcome to the CLES podcast. In today's episode, we are joined by Professor Prerna, who is an assistant professor of law at NALSAR University, Hyderabad. Prerna teaches a course on law and poverty and works closely on question of caste, social inequality, and access to justice. Their doctoral research draws on critical legal theory and lived experiences of caste, visibility, and transness to examine the limits of anti-discrimination law, particularly with how law engages with deeply unequal social realities. Before we begin with the Q&A and further introduction, I'd just like to say a few lines about what CLEF and CDPP is. So this podcast is brought to you by Center for Law, Economics and Society, which is an initiative of Center for Development Policy and Practice. CDPP is an independent research institution working on economic and public policy issues with a strong focus on the development concerns of marginalized and vulnerable communities that we will be talking about today. Through CLES, we aim to explore how law operates in practice and how it interacts with society, economy, and governance in India in general. I'm your host, Momita, and in this episode, we'll be discussing caste, crime, and the Indian justice system with a focus on how social hierarchies shape experiences of policing, court, as well as incarceration. Welcome to the podcast, Prerna. It's great to have you with us.
Thank you for inviting me. Really excited to be here.
Great.
At the outset, I would say that I am not a criminal law specialist. I
Huh.
am a teacher of law and poverty. So my orientation or dispensation to look at this entire question of caste and criminality comes from that position of who is marginalized because of, again, their poverty status, and why are they poor, and obviously like caste has something to do with it.
Hmm. Yeah. Thank you so much, Prerna. I think that adds to your introduction and makes it more better for all of us to understand. So I'll just begin with an intro question, as in we know that the Indian legal system is based on constitutional values like equality and fairness, right? But in practice, we have seen that that does not come into play. So how does caste and tribe interact at the early stages of a criminal case, such as accusation, arrest, or being kept in custody before trial?
Right. So again, I would answer this question uh, from first of all, like kind of give a context on a historical basis that why exactly do we need to complicate criminal processes, and kind of try to look at it from this perspective of caste that has been like obviously people have been writing about it, but now that we have a judgment like Sukanya Shanta, and she's looking at caste, how caste prevails even in prison system, we need to kind of take a step back to see that okay, before a person finds their way into the prison, how is caste operating, right? So before the constitution comes into play, in the 19th century, we have a law, again, it's a colonial law called Criminal Tribes Act of 1871, which kind of gives sweeping powers to colonial police to maintain registers of people who they term as criminal tribes. So, part A of the Criminal Tribes Act talks about criminal tribes, part B talks about eunuchs, right? Again, a word that has gone out of usage but translates to trans people. Now, the reason why the colonial police wants to maintain register of such people under the Criminal Tribes Act of 1871 is again is very interesting, because these are people who in the eyes of the colonial police and the prevailing colonial government at the time are people who are not tied down to one piece of land. They don't lead sedentary lives. These are people who quote unquote are seen as deviant to the kind of life that the colonial government wants to regulate, and can regulate in the form of taxation, because only if you're tied to a piece of land can the government tax you, right? So if you're moving about from place to place because you don't believe in a sedentary lifestyle, you are someone who is in one sense a khana badosh kind of, or a nomadic lifestyle. uh, that was something that was seen, that is inherently deemed as suspicious by the government, right? And this presumed criminality comes from there, that this just your lifestyle, just the way in which you live your life makes you a criminal. And therefore, it gives the police the power to maintain a register, kind of to tell you that, okay, we are going to constantly keep a surveillance on you, that to keep a check on your whereabouts. So if we think about how before in the, like, if because you asked that question, right, that how exactly in the arrest stage, like from accusation to like charging of an FIR and all of that, we have to go much before to see that how certain people are deemed to be inherently criminal or deviant because of the kind of lifestyle that they're leading. Right? Now, obviously, once we have a constitution, within the constitution, there was this sect of people who are kind of saying that yes, we can't really continue usage of these words like criminal tribes, or because it's deeply offensive to people. So obviously it is done away with. The act is no more. But just because an act is no more and is repealed does not mean that the inherent like the morality with which that was being, the presumed deviance of it is something that goes away as well, right? So we have, again, after that, something called Habitual Offenders Act. And this is something that comes in state after state. Different states are kind of have come up with different iterations of the same thing, that yes, we are not really deeming a particular caste group per se as criminal, but rather these are habitual offenders, the social anti-social elements for that matter, who are habituated to a life of crime. And so you'll see that it's like by a sleight of hand, they are doing the same thing that they could not do directly. So and that's what, like, one sees that this is again the kind of crimes, and because different states have different kind of rules that they have with regards to uh, what exactly is the procedure to for that the police can kind of do when someone is kind of picked as a habitual offender, right? And so there are like terms that are like really popular, or again is used isn't like common across users. Something like history sheeter, someone like who's or for that matter someone who is like habituated to crime. So it would be interesting for us to see that, okay, what kind of crimes were they picked up for? So if we look into that, if we go into that particular domain, we find that someone is being considered a history sheeter for just living their life the way they are like used to, right? So for a denotified tribe in Madhya Pradesh, if they are someone who again as a tribe, they brew some kind of a country liquor using mahua flower, that in itself is considered again, and it's not that it's a direct kind of criminalization that's happening, because that would be very direct and very on your face. But then again, there are a network of laws that are used to criminalize these habitual offenders. So we would have something like wildlife protection act that would come into picture, forest rights act that would come into picture, excise laws that would come into picture, because considering that the person is making mahua in a forest, so like mahua comes from a particular flower comes in a forest, and so the person is breaking multiple laws, excise laws, forest rights act, all of that, and as a result they are habituated to do it. So habitual offender bhi wo ban gaya in the process, right? So I would say that it's interesting to take a look at the historical wala thing as well, that while yes, this thing about uh, like when exactly do they get accused and what is the process of and we'll come to that as well in the other questions that we have. But I really wanted to kind of chart out that as well, that how criminality in that sense, and corporality and caste is something that we have to kind of historically look into as to what has happened then and what's happening now. And that is something that's how I wanted to kind of start this conversation today. Yeah.
I think, yeah, that's, I think, a great start because history does play a part even today. And some of the like you said, the viewpoints, it is still continuing in the meantime that we are seeing. For example, let's talk about the prison statistics of India of 2023, which again was released in 2025. We are moving a bit backward, but no, it shows that almost two-thirds of the under trial prisoners belong to SC, ST, and the OBC caste, right? And at the same time, we are saying in our news channels and online media that we are consuming every day is that people with financial resources and social resources who have done a bigger crime. It is getting easier and quicker for them when it comes to being part of the legal system. So, why is that happening? And what is the experience like for people who are from these communities?
Again, I would, because I would respond as a law poverty teacher, right? So we have we do a reading with, and the entire premise of law and poverty is the core argument that we bring. The central argument of the entire course is that law can empower, law can impoverish. So there is like, it's a two-edged sword that, and because of the question that you're asking, that with the prison statistics, the kind of population that is under trial prisoner and coming from that particular community, the experience of the resource and the privileged with the criminal justice system is different from people who are coming from marginalized backgrounds. There's something about that's, again, year after year we are getting that data, but people have been talking about dual legal system that's prevailing in this country. The Indian legal system has been going through this crisis because caste is something that is pervasive, right? And as more and more people are looking at it from different perspectives, be it from the perspective of who has resource, who does not have resource, in terms resource, not just monetary resource but also legal resource. So again, Upendra Bakshi kind of write about it, I think as far as dating back to 1980s, when he's talking about crisis of the Indian legal system, where he says that Indian legal system is not one legal system. At least there are two parallel legal system that's going for the rich and for the poor. So as you're pointing out that, okay, the experience of a person who is resource and privileged, the way, the moment they come to brush with the police or some kind of criminal transgression that they do, it's very different from how work things would work out for a person who's coming from SC/ST, OBC background for that matter, right? So just to give an example, and it would kind of give us, I'll I'll, I'll kind of keep it to uh, actual examples that can help us contextualize the problem that is facing, right?
Yeah, yeah.
How many of us have experienced Indian weddings and the kind of lavish spendings and the kind of gatherings that happen? And I think some months ago there was something that was making circles on the internet, that some rich businessman's son was getting married, so
Yes.
entire road was kind of blocked for us for some barat procession that was going on. And that's something that is very common. We have all experiences living in different cities of India, right? What did I tell you? That there is a community in Madhya Pradesh, because of the fact that they are a denotified tribe, Pardi community, uh, and therefore, if they have a wedding in their family, they have to file an application before the local police station stating that, okay, I am going to have a function, it's a marriage function, and they also have to, with the application, they also have to give a list of guests, because the law kind of says that if these many number of a particular number of party people come together, it's like law presumes because of that habitual offender act is coming. This is like they're conspiring to do some kind of criminal activity, which is like bizarre.
I know. Yeah.
That's like a person coming from a privileged background would not even think of
No.
doing a party. Party is party. Wedding party is something, this is some part of our culture and all of that. But again, this was like a very simple example, but kind of coming back to the under trial question, right? Like if we look at the, again, I look at it from a poverty lens, right? That someone is an under trial means that they can't even, like, because of the fact, the way in which this entire system is arranged, they have not even been able to get bail, right? So having the, obviously, like, resources, something that there is, like, and as I already mentioned, informational resource, legal information resource, and monetary resource. If you look at the kind of bail conditions that are really imposed on the poor or people who do not really know what exactly can they ask from their lawyer, first of all, it's considered a fortune if the poor can afford a lawyer who can represent them efficiently. But it's most of the time it's a deal. Like, the lawyer gets you a deal and you can't even question that what is the deal that you're getting, right? So, and because the like, again, states have different kind of judges are kind of playing their own, like, again, district judges, sessions judges, when they are kind of giving bail orders, we will have these kind of cases where, like, the expectation is that the person who is a migrant labor, for instance, if they're a migrant labor, one of the conditions, as a surety, you have to produce some kind of land document or some kind of a vehicle registration document. And this is something where, like, and they're not taking money, like, which is like, again, if even if they're taking money, there is an additional thing to prove, additional asset that you have to show, that okay, I also have this which binds me to this particular place. Many people don't have that. Many people do not have someone who can, like, give an affidavit on their stead, because they might be estranged from their families, or families might be really scared or worried to be implicated in the process. Not everyone is placed similarly, and that's what is a very, very telling thing, that who can even secure a bail. Do people know that okay, they can demand for a personal recognitions wala bail, the fact that I promise, I kind of give an undertaking that I will keep showing up uh, for appearances, even if I am set out on bail. Right? On top of that, there's one more question. I would just flag it, that because the informational resource is also missing. People who are, for instance, if the crime for which, or if the offense for which a person was put under trial, the maximum punishment is for 3 years, right? And the person has been behind for almost 2.5 years. Now, the question is, once somehow they get a lawyer and all of that, the question is that should this person who's already served 2.5 year in the prison system, should they kind of go out on a bail? Should they try for a bail, or should they kind of actually let it go to trial this time and have that possibility of getting an acquittal, getting their name cleared? Many a times, people, because they're missing that resource, people who are not coming from the second track of the dual legal system, who don't have the informational resource or the money resource, the moment they get a lawyer, they'll keep pleading bail, bail, bail. But bail means that, oh, you are still, your name is still not clear, you still have to keep going and making those appearances, which is something that lawyers are also not telling them most of the time, because uh, who's doing legal aid work, right? So that's something that is the way I approach that question, that yes, monetary resource is lacking, but so is the informational resource. That if someone were to give that kind of informational resource to the under trial who has already gone 2.5 months, the better advice would be that you go for trial and get your name cleared once and for all, rather than like trying to get a bail order, which would kind of keep harassing you in this process. Yeah.
I think, yeah, my next question was going to be about legal aid, but I think you have answered it very well that most of us are not motivated to be a legal aid personnel. And it does show in our, statistics and our reports as well. I think the government itself has realized that yeah, it needs more work to do. So, Prerna, we talked about the overall India. I think you mentioned Madhya Pradesh as well, right? But other than Madhya Pradesh, we are seeing the same high numbers of under trials in UP, Bihar, Punjab, and Haryana as well. So I just want to ask, should the government, should policymakers, should the lawmakers also focus on these regional discrepancies that is happening, and why should they focus there?
I would say certainly, because again, the statistics that you picked up in terms of like how states are doing differently, it would require policymakers to get confronted with the reality that caste operates differently in different states, and the kind of and the way in which how people are kind of experiencing caste in terms of it doesn't really have to be like the way I would say that when the Criminal Tribes Act was happening, it was very on your nose kind of a direct kind of a thing that was happening, and with habitual offender, it's much more not it's a little less direct, right? It's happening like in various ways. I would also say that when we're looking at statistics and finding out that different states are kind of doing or kind of showing high number of scheduled caste people as under trials, it kind of goes on to like as a researcher, it would require us to go and look into what is the caste makeup like in this country, who is, and which would go on to say that when we are looking at people, for instance, just to give make an example again, right? Uh, I think the Rajasthan prison manual, no, it's the West Bengal prison manual. I'll need to check this particular one. That it kind of had a requirement. It kind of have, and in the rules, it kind of said that a certain habitual offender coming from this particular caste is prone to absconding, is prone to doing this. So the person like who would be appointed as a night guard in the jail cannot be a person coming from this community, right? So which means that when we are looking at when we are going to the granular level, to the micro level, and saying that okay, how is caste operating in these particular states, unless and until we look into these prison manuals or like to see that like in the day to day how exactly caste operations work, right? And that's what like one in one sense the Sukanya Shanta petition does that, right? That it gives us this thing that who cooks, who cleans, and all of that. But additional things that kind of come into the picture, which are that when we're looking at individual states and how exactly caste is operating, we can only get to know about it if we closely engage with the laws that are prevailing, the state specific laws that are kind of prevalent there, and obviously the caste, who makes the dominant caste there, and obviously who makes the caste that is made to do manual labor for the rest of the uh, prison or the police station. So I also wanted to bring out this thing that uh, I think in the last year or so, we have been having Odisha High Court, for that matter, has been kind of having this thing there where when they're giving out bail orders, they are also kind of putting additional conditions
Okay.
that person is supposed to, again, person is from a particular Dalit group. Apart from the regular surety of whatever bail bond and all, they are also kind of putting on this thing that they have to do community service of sweeping the police station. Like how exactly is the judge getting that power to put an additional condition, like if the law, and that's the thing, like as and like we think that positive, like as legal critical legal scholars, we feel that positivism and that what positivism does is that positivism is too hardline law, we should be like more critical and all of that. But for judges like this who put such additional conditions that you have to do community service, where in the law have you been given this power that you will assign which caste community should be doing sweeping or manual labor or cleaning of toilets? Because that kind of when that kind of shows the casteist inherent casteist mindset that you have. So to answer your question that why certain states are having that kind of a data, much of it is to kind of come from this fact that what is the caste relationship is like, who are the people who are kind of getting into these positions of judges who would be denying or would be kind of giving bail orders, right? So I would respond to it like that. Yeah.
Yeah, okay. That's great actually. That does answer my question about how, like you mentioned, connects the historical context to the everyday social attitudes of not just the judges, the police officers, the one that, a history charge sheeters we are being called if you belong to certain tribal community. But I'm sure as a professor, you're teaching in your classes about Kimberly Crenshaw's intersectional theory. And then what we see is that people who are the most marginalized, for example, can be people who belong to scheduled caste, scheduled tribe, or OBC, and are also part of that, transgender community at the same time. So, is like, are they facing the same challenges, or are there more nitty-gritties to it?
Mm, So I would say that while initially it was so people from the trans community and people from the from people who were initially clubbed in like who were termed as criminal tribes, right? You're saying that different challenges or same challenges.
Whether they are facing the same challenges or are they different? For example, I might be like, if I am part of the transgender community, but I am also an SC or an ST. Is there something like I am anyway, the question is that हाँ ये तो है ही नहीं society के chart में. But then there is an addition that oh, they now also belongs to the transgender community. So will I face harsher punishment? Like how will the the legal system react to me?
One way the legal system reacts again, first of all, it would be like the kind of while surveillance is happening to both community, like in terms of both of a person's identities, if they're trans, yes, surveillance is happening. And for that matter, trans people are not a monolith. Trans people, like we know that who is hyper visibilized within the community is trans women, because the presumption is that the kind of offenses that apply to them are a little bit different from the kind of offenses that apply to people who are termed as habitual offender. For habitual offender, the typical kind of a charge is criminal conspiracy to do theft, dacoity, or some kind of a something to do with like property related offenses most of the time, right? But when it comes to trans women, and also like they're very hyper visible, like especially in a state like Telangana, uh, where again in the last few years they've been having this entire thing about real trans women, fake trans women, and all of that illogical thing. But at the same time, the kind of charges that are put against a trans woman just for existing in a public space is that, and that's something that comes from the Criminal Tribes Act per se, right? Inherent sense of policing trans women has been that why are you, and they would use the term eunuch at that point of time. The law was worded in a way where just the intention of appearing wearing clothing of the opposite gender in a public space, that gives in itself the power to the police to arrest you without a warrant. So we have, and that's why we have this entire case of, I think it's a case of Queen Empress versus Kherati, where the person in question, presumably a trans woman who is wearing who's seen to be wearing women's clothing, and again, in the eyes of the law, they are a eunuch, and right now, the police does not have any need for them to go and arrest them, just that the person is existing in a public space. The police goes and arrests them, then conducts a couple of medical examination on their body, and that's something that's textbook of what we are seeing right now. A trans woman is existing outside of a railway station, at outside of a metro station, anywhere. Police kind of finds out that okay, why are you existing? You must be either doing some kind, either you must be soliciting for sex work or you must be begging. Again, both of them are kind of, again, when we say network of laws, these are the network of directly nahi ho raha hai, right? When it comes to people who are like the denotified tribes, it's excise laws, wildlife prevention, and forest right. यहाँ पे आप beggary laws लगा दे रहे हो, यहाँ पे आप सीटा पीटा लगा दे रहे हो, like prohibition of immoral trafficking, and ये सब लगा दे रहे हो. That why are you soliciting for like sex work? But like once they are in the eyes of the criminal legal system, they are people, again, they're seen as people who need to be constantly surveilled. And once they are like picked up, again, you have to do this entire process of having to navigate. What do you do? How do you kind of navigate your process? And most of the time, the struggle is the same in the sense that both lack the kind of resources, informational resource or the monetary resource to actually deal with the system. For trans people, it becomes like who can provide, like who can be a surety bond for you. Most of the time, we see that they're estranged from their families, right? And if they are having to ask a friend, and many a time because of the community is knit that way, there's kinship between trans people. The police would, or the judge magistrate would say that I don't really recognize you as family. Family means family by blood. Who are you? Right? So you see that these are the kind of struggles. While it might not seem very obvious, key what's the difficulty that's coming in terms of why is it that people from these separately marginalized communities are kind of facing the same kind of struggles when it comes to being under trial for longer periods of time or not getting adequate legal representation. It's coming from that means it starts from the same start point, and because of their lack of informational resource and legal resource, and how the world or how the legal system has kind of arranged that who counts as family to give affidavit for you. So I would respond to it by like that
Yeah. Okay. I think we are just going to conclude now. And I think my final question to you would be, like you mentioned, right? There's a lot of things that are lacking. So, for you, what would be the practical steps that you can suggest to make the justice system more accessible and fair, but also at the same time we have the strengthening of public trust as well as public morality and understanding of why marginalized communities are facing that way and how our attitudes also play a part into that.
mm, I would say again is that, like, if I say that okay, we should be like we should strengthen the legal aid system, and we should see to it that legal aid, efficient legal aid is provided to people so that people are not kept languishing in the jails. Yes, all of that is important. People have been writing about it and trying to do the work as well, that yes, there should be more people who should be doing legal aid work and all of that. But let's be real, legal aid does not really pay that well, and also the fact that it's overworked, right? What it also kind of gives us that okay, how do we think of this problem that has been there before our eyes for a long period of time, and it's not that one thing is going to help. Like if there is a big problem that's there, and it's something that has been shown to us, it's quite a big problem, so we need to attack it from multiple ends. And therefore, because I have been mentioning throughout this conversation with you that legal resource is something, or resource, lacking of resource, monetary resource, legal resource is something that's really there. Uh, I would also think that it's time that we as a people who are invested as law students or as students who are really interested or in trying to work something towards this end, to kind of see to it that okay, how can I build onto the resources that these people have in terms of information, right? Which means that trying to the kind of conversation that we are having today, but even though while we are kind of coming out of the domain of the university space and trying to make it much more conversational, not like a class setting, so that more and more people can learn or kind of watch it or have their views on this, if they have if they are really thinking about this question. But it also kind of wants us to say that okay, what role do the people who are actually having in like who are having to deal with this reality, what are we doing to them and with them in the process, right? So interestingly, there are like two strands of doing this kind of work, right? So a lot of law schools right now have this thing about they run clinics, poverty clinics, law and poverty clinics.
Yeah, I think
I
NALSAR has one, if I'm not wrong.
Yeah, but yeah, it has have that. So even I ran a transgender rights clinic a couple of years back, I think 2 years back. But interestingly, what happens is that students also, and like the professors also automatically run towards we will do legal aid. We will tell you what advice should go, what application should go. But the thing is, people who are living like in this constant state of precarity, that they can be picked up at any point of time, because this constant surveillance that happening from the police and the incarceral system and whatnot. We also need to be like honest about that. We need to depart with that information, that okay, how do I tell the community that okay, this is, and in a way that can work out for them, that okay, if the police comes, these are the kind of things that you need to be ready with, right? Or these are the things that they can't do, these are the rights. So one of the things that I would say is that how, as a law people, as people who are lawyers and law students, like as a collective, right, how do we do learning of CRPC or BNSS, as you would do it, in a way which actually helps the community? That these are the things that we, and again, one beautiful way in which one can think about this particular, again, the code of criminal procedure is that it is like a charter of citizens' rights, that these are the things that the police can't do. So with this requirement that okay, if it is a person, a woman who has to be arrested, these are requirements that a woman police officer or a police constable who needs to be there at these hours of the day, or for that matter, this information that a young tribal person, like if it is a tribal belt which is prone to people getting picked up for whatever made up false charge, like parting this information that okay, if someone is below 18, juvenile justice, the protection of juvenile justice acts apply to them, right? So, and again, I know it might seem like okay, they would not, like it would not, the community would not be receptive to be knowing all of this information, but it is our job to kind of not think of ourselves as saviors, that we will kind of sweep in and give them legal aid, give them legal resource, so that yes, legal aid is important. When they need that kind of thing, then obviously they will be given that aid. But then again, also impart with that information, so that in the time being they can kind of, which means that developing a community of paralegal volunteers, that obviously law school education is something that not everyone can get at the outset. While we want more and more people, obviously want more and more people coming from the communities to go come and get legal education, so that they can have, they can be those lawyers who represent people back from the community. But when it is not happening, or if it is taking time, how do we impart our knowledge in a way that can help them at least have this information, that okay, this is example, the bail, under trial bail wala example that I gave like earlier, right? That if the person is already served 2.5 years, if they had the information that okay, if you go for a trial, there is this thing that you will be acquitted, there's a possibility of you get clearing your name once and for all, versus you going for a bail now, right now, once you, even when you have served just 2.5 years, the constant haranguing that you will be facing if you get, even if you get a bail, ये तो एक resource है which we need to, which we need to learn how to part, right? And this is going to be like a constant process, that how do we communicate, and we need to communicate, it's our responsibility to communicate.
Yeah, thank you so much, Prerna. Thank you, Prerna, for sharing these important insights. And we really hope, like you mentioned, that this conversation encourages our listener to think more critically about equality, access to justice, and everyday realities behind the constitutional and the legal promises. So thank you so much.
Thank you for having me.
Thank you.